I am Pastor Adam, and I am here with our dear friend and lifelong member of Clackamas United Church of Christ, the Reverend Charlie Hinkle. And Charlie is also a lawyer, a retired lawyer, now a consultant. And Charlie was, hi, Katie, good to see you. Charlie was the main lawyer for the Portland ACLU for about 30 years. Is that right, Charlie?
Yes, that's right.
Yeah, about 30 years. And many of you know about the recent Supreme Court decision that New York could not cap off the number of people at worship services for religious reasons, and said that was against the First Amendment. And this has created all kinds of problems, anxieties about the Supreme Court, the direction that it is going in. And I wanted to bring Charlie on to talk with us about all of this. And Charlie, thank you for being here.
Thank you, Adam. Thanks for inviting me.
You are a gift to our congregation. You're a gift to me, and I always enjoy hearing what you have to say about these important events that are happening in American culture. We've already got Katie saying hello. Hello, Katie. And friends, if you are watching this and you have questions or comments that come up while Charlie is talking, when Charlie is done with his presentation, we will bring in your comments and questions. So feel free to put those in the chat section. So I'm going to take myself off screen now and let Charlie talk to us about this recent Supreme Court decision.
All right. Thank you, Adam. I think probably everybody knows, certainly everybody listening to our broadcast this morning, that the First Amendment to the United States Constitution protects the free exercise of religion. But like every other constitutional right, this right, the right to free exercise, is not an absolute one. It can be restricted in certain circumstances. There was a famous case over 150 years ago involving the claim of the Church of Latter-day Saints, the Mormons, that they had the right, protected by their religious liberty, they had the right to engage in polygamy. And the federal government had a law that was applicable in all of its territories. Utah at that time was still a territory of the United States. And the Supreme Court said, yes, that law of general applicability, that's neutral, that applies to everybody, regardless of their religion, will be upheld. It is not a violation of your freedom of religion to be told that you cannot engage in polygamy. At the time, Mormon men were actually required in some circumstances, required by their religion to participate in polygamy. And the Supreme Court said, not on our watch. That is not a right that is protected by the First Amendment. So it's been a long-held doctrine in our society, in our court system, that free exercise of religion has to give way occasionally to other interests. And how we balance the public health against freedom of religion is a recurring problem that has been much on our minds and much a matter of discussion in the past year. But it's not just in the past year. There have been many court cases right here in our own county where our church sits, Clackamas County, Oregon. Many court cases in recent years involving criminal prosecutions of parents who have refused to get medical treatment for their sick children. There's a cemetery about 15 miles from our church in Milwaukee where you can see row after row of graves of infants and young children who died not back in the 19th century, but who died in the last 20 or 30 years because their parents refused to get medical treatment for them, because they believe in the literal truth of the passage in the letter of James in the New Testament that says when someone falls ill in your household, you should call the elders of the church to your house, have them pray over the sick person, and the prayer of faith will save the sick. That's the promise made in the letter of James. And a great many children have died in Oregon and elsewhere because their parents literally or believed in the literal truth of that verse in the letter of James. But Oregon courts have held, and courts in other states have held, that parents who refuse to get medical treatment for their children can be prosecuted for criminal neglect, criminally prosecuted for neglect of their children. And their religious beliefs are not a defense to those kinds of prosecutions. So again, religious liberty must sometimes give way to higher values in our society. And preserving and protecting the health and safety of our children, and indeed of all of us, is certainly one of those higher values. It isn't always easy to find the right balance between public health on the one hand and free exercise of religion on the other. And finding that correct balance hasn't been made easier this past year because of the failure of the federal government to come up with a coherent strategy to address and control and contain the coronavirus before it became a pandemic all across the country. The federal government took no action. And so the states were left on their own to decide what steps they would take to fight the virus. And one step taken here in Oregon, and by the governors of several other states too, was to restrict the number of people who can gather in any public place at any one time. And that's brought about a dramatic change in the way that businesses do business. It's brought about a dramatic change in the way that theaters can operate. They can't operate at all in most places now. And of course, it's dramatically affected the way that churches, synagogues, mosques, other houses of worship, it's affected how they operate as well. We experienced the change firsthand here at Clackamas UCC. On March 12th of this year, the governor of Oregon prohibited large social and recreational and spiritual gatherings of 250 people or more. Well, our congregation at Clackamas UCC is considerably smaller on the average Sunday than 250, but we immediately canceled worship services beginning with that very next Sunday, the first Sunday after the governor made that order, starting on March 15th. And 2 days after that, the governor amended her order to say no gathering, instead of saying no gatherings of over 250, now it was to be no gatherings of over 25. So we at Clackamas UCC were in compliance with the order even before it came out. But other churches in the state felt differently. And a number of them from all around the state, all corners of the state, sued the governor, arguing that the restrictions violated their religious liberty rights, and also arguing that the authority, the legal authority under which she operated to issue these orders, had in fact expired, and she no longer had the authority to issue this kind of order. Well, a local judge over in Eastern Oregon agreed with that second argument. He ruled that the authority under which the orders were issued had in fact expired, and that nobody in the state, churches, businesses, nobody in the state had to abide by them. The governor immediately appealed to the state Supreme Court, and on June 12th, the court agreed with her and reversed that lower court decision. So we have been operating under the governor's rules then, or some variation of them because they're modified from time to time. But the state and our church, all churches in the state of Oregon, have been operating under those rules ever since early June. Meanwhile, governors in other states were issuing similar orders, also restricting public gatherings. And as night follows the day, people sued to block them, to have them overturned. 3 of those cases have now reached the Supreme Court. The first one was on May 29th, and the court, on a 5-4 vote, said that it would defer to the judgment of the California elected officials as to how the best way was to combat the spread of the virus. It's a matter of science. It's a matter of public health. It's a matter for professionals to decide, the court said, not unelected judges. And so it allowed the governor's restrictive orders in California to remain in effect and to be enforced. In July, by the same vote, 5-4, the Supreme Court allowed the similar orders of the governor of Nevada also to remain in effect. In both of those cases, the 4 most conservative justices on the court dissented. They would have thrown out the orders. That was May, then July. I said there were 3 cases. The third case came just last week, but something happened in the meantime. In September, Justice Ruth Bader Ginsburg died, and President Trump appointed Amy Barrett to take her place. And I will say at this point, parenthetically, or maybe not so parenthetically, that there are, of course, 9 justices on the Supreme Court, and 6 of them are Roman Catholics. A 7th justice, namely Justice Gorsuch, was raised as a Catholic, but he now attends an Episcopal church. And the remaining 2 justices are members of the Jewish faith. So 7 justices on the 9-member court were raised as Roman Catholic. 6 of them are still practicing Catholics. There are no Protestants on the court, no atheists, of course, no members of any other religion. It is a court dominated by the conservative Catholic theology of the 5 most conservative members of the court. So the Supreme Court is a very different court now than it was last May, June, July. And the court's action last week demonstrated that. Just before midnight, on the night before Thanksgiving, the newest member of the court, Justice Barrett, joined the 4 dissenting justices from last summer and issued a new decision with a new and different 5-4 majority. And they ruled that the restrictions on worship services in parts of New York City violated the free exercise of religion. It was completely contrary, completely opposite of what the court had said on a 5-4 vote that went the other way in June and in July. The ruling that came down last week on the night before Thanksgiving was completely unnecessary, because by the time the court ruled, the New York governor had already rescinded those regulations, had already repealed them, so they were no longer in effect. So the practical result of the Supreme Court decision was to tell New York to stop doing something that it had already stopped doing. But the conservative majority on the Supreme Court was eager to decide the case anyway, because those justices have shown time and again that they are eager to take every opportunity that comes along to expand the rights of religious liberty as they interpret that right at the expense of other rights and interests and values in our society. The 5 justices who were in the majority last week in that New York case said that New York discriminated against religion because worship services were subject to capacity limits, while some other businesses were not. Justice Gorsuch wrote a separate opinion making that argument in great detail, and he complained that New York allowed people to crowd into a liquor store or a bike shop, but it wouldn't allow them to go to a church or a synagogue or a mosque. But that was a spurious distinction, an absurd argument. New York itself, in its brief to the Supreme Court, argued that there is documented history of religious gatherings serving as COVID-19 super spreader events. And there's no such evidence that any bike shop or any liquor store has provided a super spreader setting for the spread of the coronavirus. There's no evidence anywhere that liquor stores or bike shops play that kind of role. The risk of transmitting this virus is higher when people are in close contact with each other, a large number of people in close contact for a prolonged period of time, particularly indoors. And it's not just a question of how many people are present. The risk of infection increases dramatically the longer that this group of people stays together in that group indoors, and especially when they speak or sing. That spreads the virus more quickly, more widespread than in a more widespread fashion than any other means. Justice Sotomayor dissented from that decision, and in her dissenting opinion last week, she said this: justices of this court play a deadly game when they second guess the expert judgment of health officials about the environment in which a contagious virus spreads most quickly. But none of that scientific reality made any difference to the conservative majority on the court, the five most conservative justices. And we know that two of them, the two who've been on longest, the three newest ones, of course, Trump appointees, have been on the court only a very short period of time, but two of them, Justice Alito and Justice Thomas, Clarence Thomas, those two have been on the court for many, many years. And they have told us over and over that they do indeed have an agenda when it comes to religious liberty. The court issued many opinions in the last half of the 20th century in areas like school prayer, public subsidies for religious institutions, nativity scenes at Christmas time, crosses on public property, that sort of thing. And time and again, the Supreme Court in the last half of the 20th century upheld a strict separation of church and state. And it upheld regulations that are even-handed and neutral, even though they may affect churches and the way they believe and operate their faith. That old polygamy case is a prime example of that from 150 years ago. But there were similar cases in the late 20th century. If government has enacted a law that applies equally to all companies, all employers, then employers have to abide by that, even if they may violate or come in conflict with their religious opinions. Justice Thomas and Justice Alito don't like those decisions. And they are always on the lookout for new cases that will give them the chance to reshape the law in this area. And they have been particularly offended in the last year or two by lower court decisions like the one that came out of our Oregon Court of Appeals that ruled that bakeries violate state anti-discrimination laws if they refuse to provide wedding cakes to same-sex couples. Our discrimination laws prevent discrimination on the basis of sexual orientation with respect to employment, public accommodations, and so forth. So that means same-sex couples have the same right to get a motel room as anybody else, have the same right to patronize the local grocery store as anybody else, have the same right to go to the bakery and get a wedding cake as anybody else. And that's what our Oregon Court of Appeals ruled. Other courts in other states have ruled to the same effect. Justice Thomas and Alito violently disagreed with that string of decisions. In their view, a bakery owner's freedom of religion takes precedence over, is more important than a state's non-discrimination laws. That same attitude was reflected in the Hobby Lobby case in 2014. Hobby Lobby is a family-owned business. I'm sure some of you have patronized it. You won't catch me doing that, but perhaps some of you do. The owners of Hobby Lobby objected to regulations that had been issued under the Obamacare, the Affordable Care Act, regulations that required all employers to provide health insurance coverage for their employees that included insurance coverage for contraceptives. Well, the owners of Hobby Lobby object to contraceptives. They violate their religious beliefs. And so they went to the Supreme Court and said, these Obamacare regulations that require us to provide insurance coverage for contraceptives, those regulations violate our religious liberty interests. Thomas and Alito joined the 5-4 majority, the 5 most conservative justices, in agreeing with that argument. And the court held that those regulations are unconstitutional. So if you're an employee of most companies in this country, your health insurance coverage includes contraceptives, but not if you work for Hobby Lobby. Of course, it goes without saying that Alito and Thomas also strongly disagreed with the court's decision in 2015 that same-sex couples have a constitutional right to marry. They'd like nothing more than to see that decision overruled. They are staunch Catholics, and they have every right to be. They are staunch conservative Catholics, and they have every right to be. But their view of the Catholic faith is that same-sex marriage is forbidden under any circumstances. So what Thomas and Alito want is not government neutrality on matters of religion. They want preferential treatment of churches, treatment for churches that takes precedence over considerations of public health and personal privacy and rights of association and any other right you can mention. Those are much less important values to them than their religious beliefs. One of the great triumphs, I guess you might call it, of the Trump administration is that he was able to appoint more than 200 judges to the federal courts. Right-wing conservatives, every single one of them. And the positions taken by Justice Thomas and Justice Alito, not just on religious liberty, but on a whole host of other issues, those positions that they have taken are showing up already in the opinions issued in case after case by these new conservative lower court judges that Trump has appointed. Just last week, 3 of Trump's appointees joined an opinion written by one of them sitting on the Federal Court of Appeals that sits in New Orleans. They issued an opinion in which they said that, quote, the whole point of the First Amendment is to give religion a preferred position in our society. Well, with all respect, that's simply not correct. The whole point of the First Amendment is not to promote religion. It is to ensure that government remains neutral on questions of religion. Religion and non-religion are supposed to be on equal footing in our society. And the laws are supposed to apply equally to every person, regardless of their religious faith or their lack of religious faith. So there are some dark clouds on the horizon, I'm afraid. As I said a moment ago, it was unnecessary for the court last week to decide that New York case because the limits on the number of people at a worship service had already been repealed. But the conservative majority reached out to decide a case that it need not have decided because they wanted to send a signal that those 5 conservative justices, are going to continue to elevate religious liberty interests over civil rights protection. And there's a lesson to be learned here. Our pastor, Adam Erickson, has made the point many times that the gospel of Jesus is political. That Jesus himself was making a political statement in many of his actions and in many of his parables and sermons. Our Christian faith calls us to be political as well. When we cast our ballots in our elections in this country, we are making decisions that are both political and moral. The choices that we make when we cast our ballots have a profound effect on the life of individuals. And in November 2016, we had a choice to make. And we had a choice to make, knowing one thing was true. Many other things are true as well, but we all knew that either Donald Trump or Hillary Clinton was going to be the next president of the United States. There were other people on the ballot, but no one believed that any of them had a chance. They were on the ballot to make a statement, not because they had any serious intention of winning the office of president. But the choice between Donald Trump and Hillary Clinton was not just a political question, it was a moral one as well. And one thing is undeniable. If Hillary Clinton had been elected, there would now be a 6-3 majority of moderate and progressive justices on the United States Supreme Court, instead of the 6-3 majority of right-wing conservative justices on the Supreme Court. You may say, well, in that election 4 years ago, there were principles at stake. There were principles to be upheld. Some people said that their principles would not allow them to vote for Hillary Clinton, no matter how bad Trump was. So they voted for a third-party candidate because their principles were more important to them than the very real lives of people whose lives were going to be affected by the policies and actions of the new president, whoever she or he would turn out to be. And think about for a moment some of the actions that the president has taken, the man that we did elect to be president. Are you interested in protecting voting rights? Well, thousands of Americans have had their voting rights threatened or taken away by the Trump administration's voter suppression efforts. Are you interested in the environment? Trump withdrew from the Paris climate agreements. He wants to allow oil drilling in the Arctic wildlife refuge. He has opened up public monument lands in Utah and other Western states for development. Just this week, he took steps to remove the protections that have been in place for over a century, the protections of the Migratory Bird Treaty. These people don't even want to protect migratory birds. Are you opposed to the death penalty? In July of this year, the federal government executed a man named Daniel Lee after the Supreme Court denied his application for a stay of execution on a vote of, guess what, 5-4. In February, the court upheld the death sentence of a man named James McKinney by that same 5-4 vote. People are being put to death in our country who would not have been put to death if Hillary Clinton had been elected president. Her presidency, and I don't mean to defend Hillary Clinton on a wide range of actions. I'm talking about the choice that was before us in 2016. If Hillary Clinton had been elected, these actions of voter suppression and environmental protection rollback and all the rest would have been dramatically different. And incidentally, just so that they could make it absolutely clear how they feel about the death penalty, the Trump administration has scheduled the execution of the only woman who is currently on federal death row, having been sentenced to death by a federal court. The only woman on federal death row is now scheduled to be executed on January 12th, 8 days before the inauguration of Joe Biden. They didn't choose that date accidentally. They did it to make a statement, to throw mud in Joe Biden's eye, to have that event occur right before the inauguration. And if the past few months is any guide, the Supreme Court will do absolutely nothing to interfere with that execution. So it made no difference in 2016 whether Trump or Clinton was elected. Well, tell that to the families of James McKinney and Daniel Lee, the people who were executed or face execution now because of the appointments that Donald Trump made to the U.S. Supreme Court. Their executions have been approved, were approved only because Trump was able to make 2 appointments to the Supreme Court in the first part of his term in office. And now he's had the opportunity to make a third appointment, cementing a solid 6-3 conservative majority on the court that is going to last for decades to come. Pardon my phone. If those Trump appointees agree with Thomas and Alito that the same-sex marriage case was wrongly decided, or that the abortion rights case was wrongly decided, those 5 justices are going to place in great jeopardy those protections for reproductive freedom and for equality in marriage under the Constitution. Well, last week's decision in that New York case demonstrates that for 5 members of the Supreme Court, rights of religious liberty are more important than any other public consideration. And we cannot tell yet what the fallout from that decision with respect to COVID-19 is going to be. Dozens of court challenges to the efforts of many states to control the virus, dozens of court challenges to those efforts are pending all around the country, at least including at least one here in Oregon. We don't know what the future holds, but we know that the crisis is certainly not over. The headlines in the papers just today talk about record numbers of hospitalizations, record numbers of deaths being reported all across the country. And yesterday, the director of the Center for Disease Control said this: the reality is December and January and February are going to be rough times. I actually believe they're going to be the most difficult time in the public health history of this country. That's what the director of the CDC said. And medical professionals here in Oregon agree with him. Last week, the 2 largest Providence hospitals in Oregon set up temporary morgues in their parking lots because of what they are expecting this month. And over this past weekend, the Oregonian newspaper in Portland published a plea signed by 774 Oregon physicians, which included these words: the toll from COVID-19 in Oregon is rapidly accelerating as cold, rainy weather drives activities indoors and the holidays arrive. Our hospitals are close to capacity. Our frontline colleagues are tired. Some of the supplies we need to care for you are limited. If the spread of COVID-19 does not slow and reverse, we will not be able to provide the best care for anyone, whether they need a ventilator for COVID-19 or whether they need chemotherapy for cancer or whether they simply need a safe place to deliver a newborn baby. In the face of warnings like that we have been receiving over and over and over again from healthcare professionals, the Supreme Court's decision last week that churches and synagogues have a right to meet in large gatherings in the midst of this pandemic, that decision seems contrary to all reason. The freedom to worship in the way that we please is a cherished right in our country, but it does not include a license to harm other people or to endanger the public health. One day soon, we all hope and pray this crisis will be over. And the world is going to be a different place in many ways. We can't even begin to imagine what the long-term effects of this pandemic are going to be. But we plug along. Life goes on. And in the meantime, there is comfort and there is reassurance, at least I find it there, in some words that I ran across a few weeks ago, words that I've shared with our church council a time or two. They may be getting tired of hearing those. They are words written in the 15th century by a Christian mystic in England, a woman named Julian of Norwich. She said that Christ had come to her in a vision, and that Christ had said to her, "All shall be well, and all shall be well." and all manner of thing shall be well. And to that, I would add only the words that Charles Dickens put into the mouth of Tiny Tim. God bless us, everyone. Thank you for listening.
Thank you, Charlie. As always, you give us a lot to think about, and the history of the First Amendment and how it's been used and applied. And I did not know about the polygamy history that you brought up, and all very powerful stuff. So thank you for your reflection today. We have just a couple of one comment that I want to bring in from Christopher Hayes. I'll try to show that here. I'll read it out. It's a bit of a long one, but you were getting at this in the last part of your reflection. Christopher says, would you say that the Supreme Court's decision means that a burden is being placed on the public from one faith's group? Basically, their gathering spreads COVID, which spreads to people not attending, thus meaning that their actions due to faith is causing harm to those not of their faith.
Oh, I think that's absolutely true. You've probably seen, I hope you've all seen the diagrams that have been on some internet sites and newspapers lately about your bubble. You know, if you stay within your bubble, you're relatively safe maybe. But the problem is your bubble is not what we imagine. Our bubble is this bubble, and it overlaps with that bubble. And, you know, so it's not just you and your first grader's teacher. It's the first grade teacher's contact with a dozen other people and their contacts with a dozen other people. So when 200 people gather for worship in a New York church or synagogue, they are endangering each other, but perhaps more importantly, they are endangering every person that they meet in the grocery store, in their homes, in their schools, everywhere else. So that's the insidious nature of this virus, of any virus, I suppose. I mean, they don't recognize bubbles. We'd like to think that bubbles protect us. So yes, when the U.S. Supreme Court tells states that they must allow religious gatherings to take place, and I wouldn't say that they've said that categorically. They were taking one type of restriction, one type of regulation in one state, but it's a bad omen for the future. And if that court continues to strike down similar regulations in other states, including ours here in Oregon, then the sky's the limit. How are we going to go about controlling and containing the virus if we do not contain human interpersonal contact? Someone's posted, I think maybe our dear friend Judy Broncaro has posted on Facebook 2 or 3 times this statement that the longer we practice social distancing right now, the less time we'll have to practice it in the future. I mean, it's not going to go away, and we have to wear masks. We have to practice social distancing. We have to keep our interpersonal relationships, contacts to a minimum. And that's the only way anyone so far has discovered to control the virus. Now, God willing, we will have a vaccine. But did you hear the news this morning? You know, the United Kingdom has approved a vaccine, but Dr. Fauci went on the air this morning, said he's worried about that England rushed through the process, that it didn't take enough time to weigh all the consequences and to measure the effects of that vaccine that's won approval. So, one step forward, 2 steps back.
Yeah. Kat Cooper says, "Thank you, Charlie." It's good to see Kat.
Thank you, Kat. Nice to have you here.
Those were all. Christopher has another question, but I think that you've done it. You've talked about it. What's your thoughts on the Supreme Court and the right to not be subject to the religious values of others?
Yeah, freedom of religion means freedom to practice your own faith in the way that you want to. It doesn't mean freedom to impose your beliefs on someone else. That's why I've always laughed and been askance at people who argue that they have a religious liberty right to have prayer in the public schools, or prayer at a public graduation, or prayer at a city council meeting. Well, people who want to pray in those settings are not interested in their right to pray, because no one could possibly stop them from praying in those settings. What their goal really is to have someone else listen to their prayer. I mean, if they believe that God listens to their prayer only if you pray out loud in a public setting, then they're ignoring Jesus's words on the Sermon on the Mount to begin with. But they have a very strange view of God, who listens to our prayers only if they are uttered publicly. It's not what Jesus thought.
Yeah, Jesus says, when you pray, go into your room where your adoring fans cannot hear you, and where you cannot annoy other people with your prayers. Yes.
So public prayer is a proselytizing device. It's an evangelical device to try to convert people to your religion. It's not a genuine expression of a person's own faith. It's a fraud. So for people who say God has been taken out of the public schools, well, they have a strange view of God if they think that human beings have the power to remove God from anywhere. God is as much in the public schools as he is in any church or any home. What the courts have said cannot be done is for you to express your views about God in a devotional setting in public schools, because not everyone is going to share those beliefs.
I have one last question. And I've been meaning to bring this up in a sermon at some point the last couple of weeks, but I keep forgetting to do it. Alexandria Ocasio-Cortez said a couple months ago something to the effect of, why is it that Christians, or maybe she just said religious people, use our First Amendment right tend to use it as a power over and against people? Wouldn't it be great if Christians were known for using our First Amendment right more for helping the poor, for demanding the ability to do what Jesus calls us to do? And I don't know if that resonates with you. I don't know if she's right in saying that, but it seems to be that whenever we hear about the First Amendment rights, it tends to be about power over. I don't know if that's right, or if that's wrong, or if that's just the perception, but it's one of the things that I think people rightly reject Christianity for, because it's known for this abuse of power.
Yeah.
That's what it's right.
Yeah, we Christians are entitled to have our crosses in the public park, and our Ten Commandment memorials, and our prayers in the public schools. I mean, you've never heard these evangelical groups say that we demand the right to have a Wiccan prayer in our high school graduation. It's their prayers that they want. So yes, the First Amendment is used by these groups, and most often in many settings, as a sword, not a shield. It's supposed to be a shield to protect us from the government, to keep the government from intruding into our religious faith, or to dictate which prayers we're going to say, or when we should be able to go to worship services. It's to prevent government from exalting religion over another. I mean, that's what I said in my remarks, that it's intended to maintain government neutrality, to avoid government sponsorship, because there are 1,000, tens of thousands of varieties of religious faith in our country. And the First Amendment says we have to protect, honor each one of them, because that's what we are about, a country that values diversity.
As a shield and not as a sword. I like that a lot. Thank you, Charlie, for this great conversation. and for your presentation. It was very helpful to me, and I know very helpful to others. And friends, if you're watching this and this was helpful to you, invite you to share it with anybody that you think might be helpful for navigating these strange times that we are living in, and the Supreme Court's decisions. And Charlie's comments on politics are always, thank you for that. Elections matter, and we saw that in 2016, and we're seeing that now, and we'll see that into the future too. So thank you, Charlie, and thank you for everyone for watching, and invite you to join us this Sunday for our worship service at 10:30 Pacific here on the Facebook page and also on the YouTube channel. Until then, everyone, grace and peace be with you.